Hello and welcome to this week's edition of Wednesday Wisdom. This is our weekly video snippet segment as an extension of our monthly newsletter called Sidebarred. And if you're not already getting that straight in your inbox, just go to my homepage and you'll see that pop up on the bottom here of the screen. Go to the homepage and you'll see a pop-up box and just enter in your information real quick. And then you'll be on our list and you can get some monthly information in the form of case studies and some leadership challenges and things along those lines that hopefully will be helpful for you. But in the meantime, this week I want to talk about the executor or administrator of an estate and that person's duties and what you should keep in mind as you're writing your will or as you're determining how to best distribute your estate when you're on this side, and if you happen to be the person who's deemed or delegated to be the executor or the administrator of an estate, the personal representative, in other words, what you would be doing or what you should expect on the other side. So I just want to point out a lot of people, or I've come across several cases where the person in charge, the other family members don't feel like that person is doing what they're supposed to be doing and operating in that fiduciary capacity that is expected. And so I just want to make clear, when you're writing your will or when you're on the other side and performing the duties of the personal representative, you need to, or if you're an heir or beneficiary, you need to know what the expectations are. And I'm speaking specifically this week about the order of distribution from an estate. So basically, you have the first line, or if you have to pick an order, the first thing that's paid from an estate, if it applies, is year support for the spouse, and if there are any minor children that the decedent, the person passing away, has left. And so if that is the case, the spouse can file for what's called a year support here in Georgia. And that means that that spouse, along with any minor children under the age of 18, would still have use of property to maintain a reasonable standard of living, their standard of living, for up to 12 months after the passing of that first spouse. So that's first and foremost, before anything is paid out, before anybody starts trying to make claim to any assets of that estate. That's first. And then there are possible or whatever funeral expenses there would be that weren't already taken care of. That's next, coming out of the estate. Then next we have that's paid would be any estate administration expenses. So that could include filing fees with the court if the spouse or that personal representative is filing a petition to probate the will, or if there's no will, for letters of administration. Those petitions cost money, and they can get pretty pricey. So those costs, along with attorney's fees, any other professional fees like getting tax advice from a CPA, or things along those lines, are considered estate administration costs. Cost of selling property, if that were an option, then that's part of estate administration expenses. That gets paid next. There was so much information in this week's Wednesday Wisdom topic, so we've split it up into 2 segments. Please tune in next week for part 2 of our estate distribution discussion. Look forward to seeing you then.